counsel in the final case will come down Lakeview Center versus the Department of Revenue. Give the counsel to the appellant whenever you're ready. Okay, counsel for the appellant, come forward, please. We'll hear from you now.
Good afternoon, Your Honors. May it please the Court. I'm Frank Rayner, appearing on behalf of the law firm of Sternstein, Rayner & Clark, PA. I have my partner, Gary Clark, with us today, and we're here on behalf of the appellant, Lakeview Center, Inc. If I could reserve 5 minutes for rebuttal, I'd appreciate that. The case that's being presented today deals with a refund of insurance premium payments that were made by Lakeview Center, Inc. Now, Lakeview paid these taxes under the mistaken belief that its contractual reimbursement or payments, which are called medical assistance payments, were somehow required to be paid. Just so you understand the background, Lakeview is a contractor with the State of Florida Agency for Healthcare Administration under the Florida Medicaid program. It provides healthcare services and goods to the State of Florida pursuant to this contractual arrangement. Now, this case really deals with a very simple legal concept. Can there be taxation without legislation? I would submit to you that there is no legislation whatsoever with anywhere in this record that supports the taxation of these medical assistance payments by Lakeview. Now, the operative legislation involved in this case is 636.066. Now, that section has two sentences. The first sentence says that premiums paid by a 630 or paid to a 636 licensed entity will be subject to the premium tax under 624.509. The second sentence, and I think there's going to be a lot of discussion about that today, deals with who gets to adopt rules and regulations implementing this premium tax. Well, the second sentence is very clear, that the Department of Revenue has two duties under this section. One is to administer the tax, and number two is to adopt the rules and regulations in connection with implementing this tax. Now, the basic analysis that you are to follow as a court has been well established, and I believe can be found in a trilogy of cases for you. First, there's the Supreme Court decision of Moss Brothers. Second, there is the third DCA decision of Department of Revenue versus Quotron. And third is the second DCA decision of DOR versus Value Pack. Now, what those trilogy of cases tell you is this, that the Department of Revenue has the burden of proof in this matter. It has the burden of proof to do what? It has the burden of proof to do three things. First, to demonstrate that the department's definition of whether or not this payment, this medical assistance payment, this reimbursement that's received by Lakeview, is within the clear and definite boundary of the statutory definition of premium that's contained in the first sentence. Second, that the department's interpretation of Florida statutes represents the clear and plain understanding of the law on this matter. And third, that if there is two or more reasonable interpretations of the statute, that the narrower interpretation is the one that should be utilized. Now, also, these cases tell you that as a matter of law, tax statutes are construed strictly, and that you must also use the narrow interpretations. And we submit to you that the agency's and the lower tribunal's interpretation, the agency being DOR, are the much broader interpretation, and we would even submit to you are legally impermissible interpretations, that under the law there is no permissible way that you could use the OIR rule that was utilized by the lower tribunal to...
Until you sought the refund, though, didn't your client file these on their forms as premium?
Well, the forms are promulgated by OIR, not DOR. They're promulgated by OIR.
I mean, didn't they read the statute as to require them to make, the statutes and the rules as to require them to make this payment?
There was...
Until they got better legal advice or whatever?
Well, I would point out to you the record in this case is that not a single other participant in this industry made that interpretation. I'd point out to you...
But your client did, correct?
Candidly, yes. The fact that my client made an error, though, I don't think should be held against them when you look at the totality of the facts and circumstances and
No,
law.
but you're asking us to look at it as a reasonable person would look at the statute, look at DOR as a reasonable person would look at the statute, and I would assume your client was a reasonable person, and this is how they viewed
I don't
the
believe
statute and the rules.
I don't believe a reasonable person standard applies in this instance.
No, but I mean, I'm saying you would say that if we were to read the statute, it would be an inappropriate reading to say that these would be subject to the premium tax.
Well, no, I think the question is you get a form from OIR, and on there the only as a matter of fact, when you go look at the record in the forms, you'll realize that there's two different places that you report this revenue on the form. There's on the front page a general summary, and there's no category that allows you to report it as Medicaid revenue. There are in subsequent pages, you have the ability to report this by the source of payor, and you can report it as Medicaid. And that is what my client did on that OIR form. That's not the tax form. Just so you know, that's not the tax return that's filed. Okay.
Is your client excused from payment of the premium tax for its obligations under other contracts?
I think that's a pretty broad question. I mean, for example...
Well, I mean, they're accustomed to paying the premium tax for services they provide.
No, they're not, actually. They're a social service agency, by and large. They're not an insurance company. They're not in that line of business at all. Their primary is to deliver social services to medically indigent in the state of Florida, pursuant to these Medicaid contracts primarily. Now, they also contract sometimes with insurance companies and will provide health care services to them under insurance. Now, you wouldn't suggest, for example, Your Honor, that those payments would all of a sudden be subject to premiums if they receive payments from an insurance company.
Well, I'm going to suggest to you that I'm not that familiar with prepaid limited health service organizations.
Fair enough.
I mean, that's an animal that is recognized, as I understand it, through the statutes relating to insurance.
What's interesting about it, it is an interesting hybrid. If you look at Chapter 636, you will see that it's basically, it does both. It will deliver Medicaid, and it will also deliver commercial services under the statute. And a matter of fact, under 636, I believe it's .004, it specifically states that unless you specifically incorporate the other provisions of the Florida Insurance Code, that a 636 entity is not subject to the other provisions of the Florida Insurance Code. So it's recognized that this is a different type of arrangement that's being delivered out there when you deal with that kind of issue.
But this is a type of organization that must exist in order to be qualified to provide these indigent Medicaid services, right?
In order to contract with the state of Florida Medicaid program, yes, you must be licensed under 636.
And this is one of various types of organizations that are recognized in the insurance code.
Yes, it is. Correct.
Why would the legislature have required that one of those types of entities be required to enter into these contracts for providing Medicaid services?
Fair enough
there was
question.
some anticipation that some of this federal money was going to be coming back to them in the form of a premium tax.
We'll deal with the premium tax issue first, but second. But if you understand the nature of the whole Medicaid contracting arrangement,
I don't.
Okay. It is a fairly complex creature. What you do is it's almost like an all-you-can-eat buffet. What the government says, an all-you-can-eat buffet.
All-you-can-eat buffet, okay.
What the government says is, we'll pay you $100 per month per person, per head, and they come to you and you have to provide them all of these health care services and goods and obligations.
And that's what your client did. You said we'll provide these services to these 4,000 or 40,000 or 400,000 people or whatever it was.
Correct.
In exchange for
$100 a head.
$20-something a month, and we'll do it.
Correct.
And you say that's not a premium. You say that's just a contract to provide service.
Well, when you go to an all-you-can-eat buffet and you pay $10 to go and eat all you can, is that an insurance contract? Any contract involves the allocation of risk. That's the whole basis for the economic loss doctrine, that you're allocating risk among the parties. This is the statutory provisions which you must look at, and that's what I'm telling you, that you have to look at the legislative.
Who is most capable of defining whether this is a premium or not, though?
Who's the most
You?
capable?
Is it me? Is it the Department of Insurance? Is it our Office of Insurance Regulation?
You have
Or
to
is
look
it
at the
Department of
statutory.
Revenue?
The statutory language, the second sentence, says that if you're going to, the person who administers the tax and determines the the rules, et cetera, the interpretation is the Department of Revenue, not the Office of Insurance Regulation. It says the Department of Revenue. The most interesting part about it is the Department of Revenue has a
You
rule.
didn't answer my question. I went right back to the statute. But who is most capable of defining what an insurance premium is?
Who is most capable?
Yeah. Which state office?
It depends for what purpose you're defining the premium. For what obligation you're defining the premium. I mean, if you're defining it for a taxation purpose, the Department of Revenue should be the entity, and the statute directs you to that. The Office of...
If the Department of Revenue had adopted this rule, would you have a problem?
No. Matter of fact, we point that out in the brief, that had they specifically by law incorporated this rule, we'd understand. But you know what would happen then? We would have a chance to do a rule challenge.
How about if they
because
put a
you're saying-
definition of insurance premium that was totally different from what was adopted by the Office of Insurance Regulation?
If they did, the DOR,
Yeah,
of course they could. That's the statute authorizes
of
them.
course they could. Don't you think the legislature had in mind that, you know, the people that know what insurance premium is and who's been defining it is Office of Insurance Regulation over here? And when we use the term insurance premium, we don't expect DOR to go out and adopt all kinds of different definitions than what's been adopted by the Office of Insurance
Well,
Regulation.
and of course, we would expect some rationalization, some coordination among the agencies, but they are for totally different purposes. The regulatory purpose that is going on in OIR is basically three things. Primarily, it's for insolvency protection, okay? Second, it's for consumer protection, okay? And then third, it's for rate issues. Two of those are not
DOR
involved in all.
administers a lot of statutes for a lot of different purposes.
OIR
For
does?
collecting taxes. I mean, or overseas. You know, you have alcohol over here, you have roads over here. Are they required to go out and adopt definitions of what a toll road is, or could they rely on what Department of Transportation has put out?
Well, I think you've ignored a couple of things. First of all, the OIR rule specifically was not adopted for the purposes of implementing this tax section. The law implemented section does not give you any hint that this is going to be utilized for taxation. I think important, too, is that the DOR has a rule on this. They specifically defined when 636 entities will be taxed. They have a rule. That rule is not being used or ignored. I mean, why would you have to resort to another agency's rule when the very agency with statutory authority has the rule in place? Okay, and we pointed to you the DOR rule, and they specifically state that the contract has to be issued under 636. The record is clear here. This contract has not been issued under 636. It's a medical assistance contract issued under the purview of Chapter 409. Matter of fact, 636 specifically carves this contract out of it and says, the OIR, you have no regulatory authority over this contract. It has several provisions that remove this contract totally within the purview of 636. So if you're trying to divine legislative intent, look at those things. Think about that. Why would the legislature adopt a specific provision that would take this contract out of the operation of OIR regulating it? I mean, I think that's important for you to realize.
Mr. Rayner, I know you wanted to reserve some time. We'll
Thank
reserve the balance for you. Thank you.
Good afternoon. May it please the Court. I'm Warren Bird, Assistant Attorney General. I'm here today representing the Department of Revenue. The Department contends that this case is very simple and straightforward, and it's laid out step by step in the final judgment issued by the lower court. Once the facts were basically stipulated to at trial, the court found that statute section 636.066 imposes a premium tax on the funds received by a prepaid limited health service organization. Such an organization is licensed and regulated by the Office of Insurance Regulation. Thus, the appellant is a regulated prepaid limited health service organization. The appellant Lakeview has entered into contracts with the Agency for Healthcare Administration for the purpose of providing, as it turned out in this case, mental health services to a population of indigent individuals, in this case in the Panhandle area of the western part of the state, for a given period of time for a fixed amount of money without regard to cost or profit. That was established at trial. That functions as a contract that involves considerable risk and in the nature of an insurance contract. It may not be called an insurance policy, but that's not necessary. Section 636.066 imposes a tax on those types of contracts. It's set out clearly in the contract itself when it says premiums, contributions, and assessments received by a prepaid limited health service organization are subject to the tax imposed by Section 624.
Can you give me a simple definition of premium?
Yes, sir, I can. In fact, that's why we use the definition promulgated by the Office of Insurance Regulation that regulates prepaid limited health service organizations, and it's found in the Administrative Rules 690-203.013, and it says in subsection 6, a premium, and this isn't just a definition of premium, this is a definition of a premium that applies to a prepaid limited health service organization. A premium is the contracted sum paid by or on behalf of a subscriber or group of subscribers on a prepaid per capita or prepaid aggregate basis for limited health services rendered by or through the prepaid limited health service organization. That is the most succinct definition and the most focused definition that there could be, and I think it's on that basis the court chose to cite it in his final judgment. But the rule that was promulgated by the Department of Revenue also gets to the same point, but in a somewhat more circuitous way. Rule 12B-8.001 says, and I'll paraphrase here, that a tax is imposed on insurance premiums received during the preceding calendar year. Policies and premiums, respectively, mean and include those policies or other contracts. And keep in mind we're discussing a contract here. Appellant chooses to stay as far away from the word policy as possible, so it's a contract. Admittedly, it's a contract. This rule speaks to contracts or other agreements affecting and evidencing insurance and premiums and other considerations for such policies as described and contemplated by the provisions of Section 624.509. And then it goes on to say, a tax at the rate of 1.75% of the gross amount of the receipts shall be applied to the following types of policies. Now, appellant here wants to exclude them from this rule because one of those is prepaid limited health service contracts issued under 636, and they're arguing these contracts aren't pursuant to Section 636. But that is subsection 4 under subsection A. Subsection 2 under that same part of the rule says that the tax applies to policies and contracts covering property, subjects, or risks located, resident, or to be performed in Florida, except annuity policies and contracts. Now, if this rule were otherwise inapplicable to this case because of subsection 4 saying it applies to Chapter 636 contracts, it still applies based on subsection 2 where it addresses risks to be performed in Florida. The court then went on to decide that on the basis of the effectively stipulated facts, the imposition of Section 636.006, that it was very clear that the premium tax is applicable to a prepaid limited health service organization in Florida, and in this particular case also. And the final judgment was a mere 3.5 pages, and The logical analysis of this case, the facts that are stipulated to, and the application of these several statutes and rules is equally simple, and we would ask the court to affirm on that basis. Thank you.
Thank you, Mr. Bird.
I still haven't heard the definition of premium. I've been in this case a year and a half. He wants you to use a broad other contracts provision, saying that any other contract could possibly be insurance contract. I think we need a little bit more guidance than that. You just had a poll case here where they were trying to decide how many polls and what kind of poll to use, et cetera, et cetera. But when you go to these statutes, what is clear is that when you read this regulation adopted by the DOR, that if it's not issued under 636, the narrow construction, they adopted this narrow construction. It's not a construction we adopted. It's a construction they adopted, saying that if it's not a contract issued under 636, then it's not subject to being considered a policy or a premium.
Does it really say that, Mr. Ryan?
Yes, it does, Your Honor. The plain language here says that it enumerates a list of contracts that are
included.
that will be subject to the tax. And then what he wants you to do, I have several responses to the other contract, the all contract argument. First of all, obviously every contract deals with the issue of allocation of risk. Does this contract rise to the level of being only about risk? Is that the only thing that this is, like your insurance contract on your house? The only thing you're buying there is you're shifting the risk that your house will be destroyed by a hurricane. That's not happening here. My client has to do quite a few more things. They have to create clinics. They have to hire medical professionals to deliver the service. They have to do transportation. There's quite a few goods and services. When you look under 409.907, which is the definition of Medicaid agreement, it doesn't talk about insurance. That whole section talks about purchasing goods and services. That is what's being purchased by the state of Florida here. Nowhere in Chapter 409 does the legislature describe a Medicaid program as an insurance program. It's not described as an insurance program. It's described as a health care services delivery program, and that's what's happening. So to transmute this program all of a sudden into an insurance program for purposes of premiums, to collect premiums, I don't think is a valid or appropriate basis. And we'd ask that at this point that you reverse the lower court's decision and allow the refund.
Okay.
Thank you.
Thank you both. Thank you, Mr. Clark.